Now we're going to get down to the nitty-gritty of what Indians are all about.
I still say we Indian people are believers in the truth. This is the way of life that was given to your people. You're born an Indian, you're going to die an Indian. Indianness is a good life. You're facing an Indian this afternoon.
This week on Mvskoke Vision, we wanted to feature some great content from two of the Mvskoke Creek Nation's YouTube channels. In addition to the Mvskoke Vision YouTube channel, the Mvskoke Creek Nation Public Relations Department also has its own channel. MCN Public Relations recently posted a video about a Creek citizen who trains service dogs for veterans. Following that story, we wanted to highlight a new live streaming segment that will be on the Mvskoke Vision YouTube channel called Deep Dive. Deep Dive is a long-form discussion with a guest that is an authority about the topic at hand and allows citizens who catch the live stream to ask questions in the chat about the topic. This week's Deep Dive was concerning the Murphy case at the United States Supreme Court and features former Mvskoke Creek Nation District Court Judge Patrick Moore. Today's Deep Dive segment has been edited for time, but to catch the whole show, go to the Mvskoke Vision YouTube channel. And once again, thanks for watching Mvskoke Vision.
So I've been training service dogs for about 8 years now, and each one is different. And I try to tailor the program to each veteran because PTSD doesn't look the same in everyone. So it's actually really cool when a veteran meets their dog for the first time. We let the dogs pick the people first off, so that bond is pretty strong between the two of them. But within 5 minutes, like I had a veteran, she was wearing probably 3 sweaters and a face mask, and all of her hoods were up. I mean, you could literally only see her eyes. And she met her dog, and within 5 minutes, she was taking all the layers off. And by the end of the 30 minutes, she was playing with this puppy. It fell asleep in her lap, and her shoulders were back. She was smiling. She took all of her sweaters off. You could see her face. I mean, it's almost an immediate reaction when they get their dogs. It's really cool.
I'm a disabled Marine Corps Lance Corporal. Went in as a musician, but my body broke first. So I was in for a while, but not as long as I wanted to be. When I was home awaiting orders, a very dear friend of mine was a Navy veteran. She was retired. She'd been in the Navy for 20 or 22 years, but she lost all hope, and she committed suicide. We lose 22 a day. That's horrible. We shouldn't be losing. Not when there's people available, when there's dogs available, when there's love ready to hand. Because a dog is so affectionate, so loving, and makes such a difference.
My dad was a Marine, so I had to keep it in the family. But also the Marines are the best. I served as a military police officer, and eventually I got selected for a special duty assignment, and I worked at the White House doing security for President Bush Jr. I was one of 3 people selected out of 600, and I was one of 6 women in my unit. So I became a chef for a little while. I did that. I went to San Francisco for culinary school. And while I was working in the restaurants, especially here, I realized that I wasn't doing what I needed to do. I wasn't helping veterans, and the veteran suicide rate was just climbing. So I had already trained several dogs for myself as emotional support animals. I was diagnosed with post-traumatic stress while I was in the Marine Corps. And so I trained emotional support animals for myself to use at home, and then eventually got to the point where I needed a service dog because my PTSD was just getting worse. So I trained my first service dog, and from there it's just been, everybody wants a service dog, so why not?
In my case, he knows if I'm having vertigo, tries to prevent me from falling. If I have fallen, he stands guard over me. And then as I try to get up, he tries to figure out how to help me get up. There was a time 3 years ago, if you asked me to go to Bass Pro, I wouldn't go at all. It's too busy. There's too much activity, too much sound. For me, I can now walk in with his help, but I have to come a little earlier than I'm supposed to meet someone to get him calm. But now I can do that.
In the next 8 years, I really hope to see more veterans that are able to reach out and ask for the help that they need, and for that help to be service dogs.
the deep dive on Murphy today. In the studio we have Angel Ellis, who is currently working on getting our links up to Facebook and Twitter. And we have Judge Patrick Moore, who is going to be our legal authority in this matter. He has legal experience spanning decades at the tribe. He was the district court judge of the Mvskoke Creek Nation for 25 years. He has also been a prosecutor, the DA in Okmulgee County, and he was consulted on this case. So thanks so much for coming in. He also happens to be my dad, so I appreciate him coming in and helping me out on this deal. To get us started off, Dad, could you kind of give us the history of how you became involved in the Murphy case and what your understanding of it is, and as much information as you want to give us?
Well, the Murphy case was started by the district attorney's office in Okmulgee County because they had jurisdiction over McIntosh County. As I remember, this was a long time ago, but Tom Giulioli was the district attorney, Rob Barris was the prosecutor for McIntosh County, and I was asked to come down and visit with them on several occasions with respect to whether there was any problem with Indian country down in McIntosh County. At that time, as I remember it, the activity that they were prosecuting someone for occurred on a section line, and as I remember, a body was moved into the ditch and rather stomped and what have you. And then when that was completed, the persons involved in it left to go find the man's son who they had stomped and killed, actually, so they could eliminate him also. And that's how they got apprehended. They were caught going to this man's house, as I remember it. The issue was whether the property that they were on was restricted Indian land. And by restricted Indian land, it wasn't land of the Creek Nation, it was an allotment. And allotments are different than lands that are Creek Nation lands in that they have been conveyed to somebody in fee simple. Now that doesn't mean that they weren't Indian country under the new law.
The new law being the 1948
Well,
Major
the
Indian Crimes Act?
the Indian Civil Rights Act comes into play in the
Okay.
Major Crimes Act. Major Crimes Act was enacted, as I remember, because there were some the federal government doesn't have all the crimes that states do, and so they needed to bring in some major crimes, and they did that with the Major Crimes Act, and it's grown. But other crimes have been added.
Can you stop
Excuse me.
on
Sure.
on allotment and the difference between allotment and
Well,
a tribal hold
allotments aren't the property of the United States. They're the property of the Indian. And the Indian got his allotment by a fee simple deed from the principal chief of the Creek Nation.
Okay.
And that's a big difference. And though everybody's missing these big differences, and they're important big differences, but the Major Crimes Act and the new law where they say these communities, just because there's a predominance of Indians in a housing development out in the countryside, can become Indian country, all of those changed since statehood and since Indians got their allotments and what have you. And really, Indian nations are 5 tribes, Indian nations, have misconstrued a lot of the property interests that the federal government has and the Indian tribe has in property. They like to call everything Indian country, but the only way it's Indian country is if the allottee is still restricted. If the allottee has had children, now that's prior to the recent Stigler Act amendments, if the Indian had children and the children had their blood was less than 1/2, that land is no longer restricted. So Creek Nation had no jurisdiction over it, just by operation of a marriage.
Right. And that's the argument of the state, and this for the state jurisdiction in certain areas.
Well, that could have something to do with this case, because as I remember, the only restrict.
Do you need to go change it? Angel's going to run out, and she's going to do some alterations to it, or alterations to a story we've got going. So
You want me to stop?
no, you're good. We're going to continue. Speaking of that, let me just interject really quick. While we're talking about the case. So after you were consulted, and then we saw what happened next in the Murphy case.
Well, they went ahead and tried the lawsuit.
Okay, and you're talking about in
McIntosh County District Court.
And then it went up from there to.
They got a conviction, and of course it was I think it's a death penalty case, isn't that correct?
I believe.
Okay, so there's there's an appeal on that,
right?
And it was appealed, and the appeal wasn't successful for Murphy. And this was back in the 90s, I want to say. Do you have the exact date of when Murphy was tried in state court down in McIntosh County?
I do not have that, but I can look.
Well, it'll be in the record someplace.
Well, what I'm concerned with here is let's move forward. Eventually, this case got to the Supreme Court level, and how did that happen? What from your standpoint?
Well, all these appeals were gone through, and they ended up in the 10th Circuit Court of Appeals, and a 3-judge panel of the judges in Denver invoked a case called Solemn, which did involve a reservation, and said that this property the property where he was an Indian reservation. And then from there on, it's going up to the Supreme Court of the United States.
Well, and the argument there would be that because it has reservation status, then the only things that would have jurisdiction there would be the federal government or the tribal government, right? And so when the state conducted his arrest and everything, that they didn't have the jurisdiction to do those things, right?
That's what the allegations are.
Okay. Let's take a look.
There's another problem with that. As I remember, this land that was adjacent to that section line, there was 1/12 or 1/16 of the minerals was the only thing restricted.
Okay.
And the minerals aren't on the surface.
Mm-hmm.
They're thousands of feet down into the, and if 1/12 is enough, that was just old restricted property inherited by no telling how many people, and it could or could not have been restricted at that time, depending upon who had it.
And if we look at what we have up right now on the screen about, which is the actual question presented before the Supreme Court, right? The question that ended up getting presented to the Supreme Court is whether the 1866 territorial boundaries of the Creek Nation within the former Indian Territory of eastern Oklahoma constitute an Indian reservation today under 18 U.S.C. 1151A, and then the 171107 is the Murphy case number. So that we can understand the distinction that you're making about the restricted status of the property. The Murphy's lawyers aren't actually arguing about the restricted status. They're saying that because they believe that it is a reservation, it qualifies under 18 U.S.C. 1151A. Let's go and kind of explain to the audience what 18 U.S.C. 1151A is. So I'm going to bring up, let's see here, where is this? It's not there. No. Here. So The 18 USC 1151 is the Indian Major Crimes Act that was passed in 1948 that gave a definition of the jurisdictional definition of Indian country, which is except as otherwise provided in sections 1154 and 1156 of this title, the term Indian country as used in this chapter means A, and this is the A that is in the question on the Murphy case, all land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent and including rights of way running through the reservation. Now I'm going to mention a couple other things before we talk about that. But what I wanted to mention too in addition was the B and the C. So B is all, there's other qualifications. B, all dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. And C, all Indian allotments, the Indian titles to which have not been extinguished, including rights of way running through the same. Now, I wanted to mention those because this Indian country definition in Murphy is being challenged under the A, reservation status, right? But other people that want to get their judgments or want to challenge their convictions on jurisdictional things could also choose B and C, right? That, like, there's not just A. In the Murphy case in particular, it's A, but there's also these other qualifications. And here in a minute, there's an article I want to read some excerpts from that will kind of touch on the history of where did this A, B, and C come from for the 1948 law. But before we go there, all land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding issuance of any patent and including rights of way running through the reservation. How do you classify a reservation? First off, let's talk about that a little bit, because that's one of the things that I don't understand in the case is, to my understanding, I'm not a lawyer, but reservation status would say that the federal government is holding lands in reserve for tribal use or tribal government, right? And that they own the land. And let's talk a little bit about who owns the land at the Creek Nation, this 1866 boundaries that's referred to. What are those?
The 1866 boundaries are the boundaries of the land after the Civil War that the Creek Nation retained when the federal government made them convey lands west of, I'm going to say, the Creek County, Seminole County borders out to the Panhandle. That was originally Creek Nation land. And after the Civil War, the United States came in, and Abraham Lincoln had promised a group of politicians, political people who were called free soilers, that if they would support him to become president, he'd see that they had land out in the western part of the United States. And it was just easy after a Civil War to go in and tell a Indian tribe that you messed up and you violated your treaty with us, and therefore we're going to punish you by taking half of your land. And that's what they in effect did. There's some question as to whether or not that land was actually legally surrendered, and the deed signed by Obithiahola, who was dying in Kansas because agents from the Bureau of Indian Affairs came to his bedside in Kansas and told him that the federal government was going to have to punish the Creek Nation by taking their lands from in western Oklahoma back to the roughly the county limit of Creek County and Seminole County. And when they did that, they told Obithiahola, but we can't represent you, Obithiahola. That would be a conflict of interest for us to represent you, but we have a friend from Washington who's going to represent you in this and make sure everything is legal. Heirs and relatives of Obithiahola dispute he signed anything. And so, but they went ahead with it, and then of course that land was then conveyed back to the United States by fee deed.
And we're talking about lands in Alabama or Georgia?
No, we're talking about land in western Oklahoma.
Oh, in Oklahoma, okay.
We've been out of Alabama for a long time.
Well, it was my understanding that the land that was that the tribe received the fee simple deed for lands in Oklahoma.
That was to pay them for land they had in Georgia.
Right. Okay. So was that after the Civil War? Before
No, that was in 1830s, 1825, 1830s.
Okay. So
the deed was written in 1854.
Right, because I had read that that situation was that there were white settlers that had come into those lands, and that the tribe wanted the federal government to go in and remove those settlers, and the federal government said we're not gonna send troops down and remove the settlers.
No, because the settlers voted and the Indians didn't.
Right, and so they said we will give you something of equal value in the Indian territory.
Acre for acre.
Okay, so the situation of the 1866 boundaries that was land that the federal government actually gave the deed to the tribe as a way to make them even for the lands that were lost.
To get them out of Georgia and Alabama.
Okay, so in that situation.
But then after the Civil War, they needed some more land for some guys that supported the president.
I see.
So we'll go get the 5 tribes. They own Oklahoma from the Arkansas to Texas.
I see.
And we need that land so we can have a land rush. And the Sooners came in after they got the land back. They took it from all the.
Was that land purchased, or how did that transaction?
They took it by war.
So
they took it as a war punishment.
Oh, so
it was punishment for the Creek Nation and the chicken.
Is that
do what now?
The tribe ceded the land. Is that
they gave a deed according to what the records reflect.
I see.
The
and
principal
that's what
chief
you're saying.
at that time of the Creek Nation was Obithiahola, one of them.
And that's the disputed that he signed it.
Well, that's just what history tells us. He died in Kansas. He never got home.
Gotcha. Okay.
His ranch was down by Henrietta.
All right. So, so in your mind, or is it possible, how is it a reservation if the tribe owned the deed? Is there another
a reservation?
Okay.
Reservation's owned by the federal government.
Okay, that was my question.
That's the difference between if the federal government owns it, then they reserve it for the Navajos.
So with that question, we also have the McGirt case that has been granted certiorari at the Supreme Court that is related to this. I wanted to pop that question up and see what the difference is. So in this situation that we're going to go get back to this point about the reservation a little later when we talk about Justice Roberts asking for some more clarifications from all the parties in December of 2018. But right now I wanted to touch on McGirt because the question before the court in the McGirt case, which is also a case where you have an individual who is saying that the state didn't have jurisdiction in my case. The question there is whether the Oklahoma courts can continue to unlawfully exercise under state law criminal jurisdiction as a justicable matter in Indian country over Indians accused of major crimes enumerated under the Indian Major Crimes Act, which are under exclusive federal jurisdiction. So there is some legalese there. I was wondering if you could parse that for me. What is that question actually asking?
Well, the federal government has jurisdiction over some properties in eastern Oklahoma that were part of the original Creek Nation's deed, no doubt.
Okay.
They kept some of. There's forts and other things and post offices and federal buildings in eastern Oklahoma that are part of the United States government's land base. But to come in many, many years later, over 100 years later, and say, well, we really didn't, you had a fee simple deed, but it doesn't really mean anything, that's bunk.
Well, my question here is this justicable matter. What is that referring to? What is it saying? Is it saying the court can't hear these cases until Murphy is solved, or what?
Well, they're right now. It's in limbo as to whether the courts of Oklahoma are going to be able to handle crimes that are committed right out here on Highway 75,
Okay.
or crimes that are committed in downtown Okmulgee.
So the question here is that what the question before the court would be, is if Oklahoma under state law can continue to exercise prosecute cases?
And they can, in my opinion, this is my opinion, because the land passed from Indians a long time ago.
Right. So, but that's what this question is. That's
That's the way I look
for
at
McGirt.
it.
Okay. So they're asked that if the Supreme Court has granted cert on McGirt, what does that say about the Murphy case from that perspective?
Well, McGirt doesn't tell us anywhere in his briefs that he filed for certiorari and they granted it on actually what the land title was and the property where these alleged crimes took place in Wagoner or Broken Arrow. But there are some important things in the McGirt case that nobody says anything about. One of them is Article 6 of the Constitution and laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and judges in every state shall be bound thereby. The United States Supreme Court is supreme to Title 18. It's the
Okay.
Constitution. And the Constitution controls whether something is a reservation or a fee simple patent. Okay?
All right, I've got McGirt's filing here. You want to go in and take a look at it? See
Go
what
to
he says?
page 2 or at that second paragraph, indentation down.
All right, let's see here. You
Keep
want to
going.
go in down here. Jurisdiction. This where you want?
No, what? You page 2?
This, I don't know what page is. Page
Don't-
1,
don't
page
move
2.
it so fast.
Here we go, page 2.
Slow down a
Where do you
little
want to
bit.
start?
Right there where it says Article 6 of the Constitution.
Okay, Article 6, this constitutional laws of the United States shall be made in pursuance thereof, and all treaties made, and this is McGirt's filing, so he's
But that's what the Constitution says.
right. Okay, so,
It says all treaties made.
right. So he's saying that
All
because-
treaties made are the supreme law of the land.
yes, because the 1866 treaty, or the treaty that gave the land to,
And that was done back in the 1820s and 1830s, and the deed was given to the principal chief of the Creek Nation in 1854. Willard Fillmore was the president. He signed a deed.
okay.
They'd been